Okay.
I give you
Okay, good. Okay.
possibility. Thank you very much.
Thank you.
Я думаю, что больше Чарльз не нуждается в представлении. Я вам желаю получить все эти эмоции и впечатления, потому что я их получаю уже не первый раз, и каждый раз я завидую аудитории. Спасибо вам, что вы пришли. It is a program of corporate law and business.
Yeah.
Предоставляю слово нашему гостю.
Okay, good. Thanks. Great. Shall I start? Boss? Okay. So just making sure. So thank you very much. What we will do today is continue the discussion from yesterday. We are talking about provisions in contracts. And again, these are provisions that appear in most business contracts. They appear in acquisition agreements, but in the tech world, they appear in founders agreements, intellectual property agreements, Series A investment agreements. These are very, very common provisions. And what happens is, and you will see this over your lives as you become more experienced, about 80%, 70% of the problems that come up in deals come up in all deals, whether it's technology deal, mergers and acquisitions, capital deal. It's the same kinds of issues with the same kinds of answers. And so yesterday we spent a lot of time talking about private information, differences in information, and a large part of what a lawyer does when they are working on a deal is they try to figure out what is the missing information, create some sort of way to understand better the difference between what the buyer wants, what the seller wants, what the investor wants, what the company wants. Right? It's all based upon informational differences. And you may recall we used the yellow jiggly for those of you that were here. Right? The yellow jiggly, there is a difference in understanding of the value of the car. I am the seller. I know more about the yellow jiggly than you do, the buyer. I know people that were not here yesterday going, what the hell is he talking about, yellow jiggly? But the point is there is an informational divide. So imagine, right, I am an investor, and I wish to put money in your company. There you go, right? Who knows more about your company, you or me? You guys do, right? You know what the value is. You know what the problems are. As an outside investor, I may have some experience, but I don't know as much. Okay. So you want me to invest 100, let's say. But I really don't know if you're a good business or a bad business, because you want 100, but he wants 100, she wants 100, he wants 100. Is your business a good business or a bad business? How do I know that what you're telling me is true? Of course, everyone tells me their business is a great business. Everybody. I walk down the street, hey, Whitehead, we have the best business. Right? How do I know the good versus the bad business? How do I know the business is really worth 100? Well, if I don't know, what am I going to do? You tell me the business is worth 100, but I know that some of the businesses are really worth 0 or 10 or 20. You tell, but I don't know. Your business could be 100, could be 120, or it could be worth 20. I don't know. So what am I going to do? Yellow jiggly, right? This is our yellow jiggly problem. What am I going to do? If I don't know if you're good or bad, what am I going to do? I'm going to discount the price. There is a risk that you are really not worth 100. In fact, if you know I'm willing to invest 100, will you sell me your business? Will you let me invest in the business if the value is 110, if I'm going to give 100? Of course not, right? You're going to simply, if you are looking to maximize and if you want to pursue your own position, create value for yourself, you will cause me to invest if the value is 100 or 90 or 80 or 70. Not knowing if you're good or bad, I will discount the price. I don't know if you're really worth 100. I'll give you 80, 70, 60, right? Why? Because there's a risk that you are really worth only 10. That's our yellow jiggly problem. And so reps and warranties are a credible way to convey information. If you give me a warranty, here is the value of the business. Here are the assets. Here's the price. Here are the risks. Right? If you give me warranties, credible ways for me to rely, provisions in a contract that I can sue, now I am more comfortable. Okay, maybe the value really is 100. Right? So, if you know this information, reps and warranties, the contract is the way to give me this information. And by giving me this information, you benefit. You're taking a risk because you agree in the contract that you are warranting the value of the company, but also you benefit because instead of paying you 60 or 70, maybe now I will pay you 90 or 100 because now I have greater comfort that the business really is worth 100. Good? That was our yellow jiggly problem. That's reps and warranties, right? Representations and warranties cover this. Covenants are doing the same thing. This is where we finished yesterday. A covenant is an agreement to do something or not to do something. It's a promise. It can be an affirmative covenant. I agree I will run the business in a certain way. It can be a negative covenant. I agree I will not do certain things. Affirmative covenant, or it's a promise to do something. And remember, when we're looking at covenants, we're really worried about the period between when a contract is signed and when the closing takes place. So what normally happens? So we're using acquisitions, M&A, as our example. Remember, I'm using this just as an example. Same ideas come up when we're looking at investments, Series A, seed financing, when I'm looking at licensing agreements, all the same issues come up. So I'm just using this as an example. And typically, the contract is signed before the deal is closed, right? So I'm going to sell you my business for $1 billion. Not so bad, right? I'm going to sell you my business for $1 billion. But I agree today to sell you the business. Am I actually going to give you the business today? Well, maybe you don't have $1 billion. Maybe it takes you a week or 2 or 3 or a month to get the money. Maybe there are some approvals. Maybe we need government approval. Maybe there are some other approvals that we need before I can sell you the business. So we will sign the contract today, but the closing is where I will give you the business, you will give me money, doesn't happen for 1 or 2 or 3 months. Okay, so we agree today that I'm going to give you the business, that I'm going to sell you the business. You agree today that you will give me $1 billion. Thank you. But we agree that this will happen 3 months from now. After all of the government approvals, after all the requirements are met, after you have the money, I will give you the business 3 months from now. Okay. You're the buyer. You're going to give me $1 billion. I'm the seller. We've signed this contract. 3 months from now, we will close. What are you worried about? I'm sorry? That I will. So I'm the seller, right? But it's my business. Ah, okay, good, right? So you're worried that now that I've agreed to sell the business, maybe I will operate it differently, right? Maybe I will be a little less careful about the business because 3 months from now, as far as I'm concerned, it's your business. Give me the $1 billion, and so I don't care so much anymore. So what we're worried about is this period. The company is controlled by the seller, but in my mind, this is really your company 3 months from now, and so maybe I will not operate the business as carefully. This is where covenants come in. Covenants will say that during this period, during the period where I control the company before the closing, I will affirmatively agree that I will operate the business as I ordinarily do, right? I will continue to operate the business in the way I did before the contract. Negative covenants will say things like, I will not sell assets, I will not do things that will damage the business, right? But the idea is through covenants, we are, during this period of time, making sure that my behavior does not change, right? After before the contract was signed, here, company was mine. The risk was mine. I was not going to sell you the business. I ran it very carefully. At this point, contract is signed, maybe I'm not so careful. And so covenants balance this risk. They make it more likely that the company will be operated just as it was before the contract was signed. Of course, after the company is purchased, the buyer now controls the company. So yesterday we talked a little bit about whether you should hide things. Some of our colleagues were suggesting that maybe we might think about hiding things. So think about this, right? I am selling you the business, and maybe there is something wrong about the business. Maybe the assets are not so good. Maybe the factory is not so good. Maybe the buildings have problems with them. Now, I could simply decide to hide it. So long as the warranties, however, are credible, in other words, they are a way for me, the buyer, to get my money back, it becomes a little less likely for you to hide things because eventually I will control the company. And when I control the company, then I will get to see, is the building good or bad? Is the factory good or bad? And then I will come to you and say, hey, you told me the factory was good, clearly not so good, give me my money back, right? And we can do it because of the covenants, the contract being breached. We might also do it by way of the indemnity. We'll come back and talk about indemnities again in a moment. But the idea here is, because the contract has been breached, I can now get my money back. So what do we do? It's a credible way to convey information. It's a way in which you can comfortably convey information, and as the buyer, I can rely upon this information. Because I know, and you know, that if you lie, I will find out about it, right? Even though my friend chose not to fully disclose it, I will find out about it because eventually I will control the company. And when I control, I will have much more information after the closing than before the transfer of the business. Good so far? Okay. So, you might ask yourself, how do I monitor compliance with the covenants? Right? So, I agree as the seller. I will operate the business in a certain way. I will make sure the business continues to run properly. You might say to yourself, how do I know that Whitehead is in fact doing what he says? Well, you could agree to sometimes show up and just check. Right? So during the 3 months between the signing and the closing, very often, the seller agrees, the buyer can just show up and look around and make sure things are okay, right? That's one possibility. The other possibility is that you simply know after I transfer the business, he'll be able to check, did I operate the business in the ordinary course? Did I operate the business properly? So you want to be able to monitor the covenants. If you cannot monitor covenants, they're kind of useless. Right? The value behind them is that you're able to monitor them to decide whether or not the covenants in fact are being followed, whether the seller is doing what he's agreed to do. And either that will happen because you can check, you show up over the 3 months and you look around, or because you know that you will be able to confirm, are the covenants being followed after the business is transferred? Okay. Indemnities are provisions in contracts. So some of you know what an indemnification is. So what's an indemnity? What's an indemnification? I'm asking one person in particular. What's an indemnification? Do you recall? What does it do?
Indemnity is a special provision in the contract, or it may go as a separate part and form a single bundle with the contract with the main part.
Okay.
Indemnification can, well, it's kind of rules of behavior and, well, rules of behavior of both parts of the contract, what they guarantee to each other in some way.
Okay.
I just try to represent it in simple words as I see.
Yeah. Okay, no, that's fine. That's good. So an indemnity, yeah, an indemnity is a provision in the contract that says that if the seller or the buyer breaches the contract, right, fails to satisfy the warranty, fails to satisfy the covenant, the other side can sue to get money, right? The way to think about it is an adjustment in price, right? So, I agreed to buy your business for $1 billion, right? I agreed to buy why? Because you gave me representations and warranties that said the factory is good, the business is good, the customers are good, the intellectual property is good, right? Based upon what you told me, I said, okay, it's worth $1 billion. In addition, we entered into covenants, and you agreed you would continue to run the business. It was $1 billion business. You will continue to operate it, so it will not lose value, right? So based upon the representations and warranties, you are telling me how the business should be valued, and based upon the covenants, you are telling me how you will operate the business. I'm comfortable it's $1 billion business. Now it turns out I get control of the business and the warranties are wrong. Factory is not so good. Customers not so happy. Products not so good. Intellectual property not protected. Or maybe you did not run the business properly. It means that the $1 billion business that I thought I was buying isn't worth $1 billion. It's really worth $600 million. And so what do? Typically under the indemnity, I go and say to the seller, you sold me a business that you said is worth $1 billion. Now I can see it's really not. The information in the warranties is wrong. The covenant is wrong. This business is really worth only $600 million. Give me back $400 million. Really, we are adjusting the purchase price. Right? That's how to think about this. We thought it was $1 billion deal. Now, because the warranties are inaccurate, because the covenants are wrong, the price that I thought I was paying is too high. Give me back money. Good? The problem, of course, is it's always difficult to show that there's always some debate over whether or not the loss, the decline from $1 billion to 600, is because the warranties are wrong or something else. So we may fight a little bit, right? I will say, well, the value should be 600 because this warranty is wrong, this covenant is wrong. You might argue that the value of the company changed, nothing to do with the warranties, nothing to do with the covenants. We'll have a little bit of a fight. But generally speaking, right, warranties, representations, covenants create this baseline of information upon which we can discuss pricing. Good? Right? Again, I said this yesterday. Some of you were not here, so I will say it again. Right? You are efficiency engineers. You are transaction engineers. No, it's okay. Oh, the people in the front row who are late always get called on a lot. I'm kidding. You are transaction engineers. What does it mean? It means that you are in the business to convey information in an efficient way so that we can value the business. I know lawyers often don't think of themselves this way, right? Lawyers say, oh, I'm just some guy that does paper. I'm some guy that worries about lawsuits. I'm some guy that worries about the risk of being sued. But that's really only part of the function. Yes, it's part of the function, but it's only part of the function. What you are really doing is conveying information or learning information in order to better understand the value of the deal, the value of the investment, the value of the intellectual property, the value of the acquisition, so that you can, with your client, decide what the proper price is. Right? That's very much what this is. And so what do you do during negotiations? Again, for those of you that were here yesterday, don't say it. Okay, what do you do? What's the word that you always use during negotiations? Always use. You shouldn't say it. You say, yeah, right? Yeah, the word why, right? I want this representation. I want the representation that the factory is good. You say no. What do I say? I say why. Tell me why you cannot give me this representation. I want to know that you will operate the business as you have operated before. Covenants, that you will continue to operate the business in the same way. You say no. What do I say? Why? It is the word that you should use very often, maybe the single largest word you will use during a negotiation, because you are trying to convey, understand information. It goes to value. You're not the ones negotiating price. Your client negotiates price, right? But they need to have the information that you are getting in order to understand the value of the deal so that they can negotiate price. So the two are related, right? This is very much where lawyers are part of value creation. You are very much a part of executing an efficient deal where the value is reflected in the contract. If it's not in the contract, you don't rely upon it. It's got to be in the contract. The contract is the enforceable means, putting aside fraud, guys that lie. Putting aside fraud, the contract is the enforceable means by which you can judge the value of what you're buying, the value of the transaction. Good? Хорошо? Okay. Kamchatka. Good? Okay. So let me use an example, by the way, of what covenants do, right? How covenants affect value. What I'm going to use actually is an example, not just to show you that this happens all over the place. I'll give you an example outside of the acquisition world. This is a case involving Marriott International. Do you know Marriott International? Big hotel chain. Okay, and Marriott International did a spin-off in 1992. A spin-off is where you take a division of the company and you create a separate company and put it in the division and give the stock of that company to your existing shareholders. I'll show you in a moment how it works. But the idea here is I'll take my existing company, break it into two. The stockholders will be the same. I'm just breaking the company into two, is what they're doing. Okay, so Marriott in 1992 have two businesses. They manage the hotel. That generates about 70% of their revenues. And they also have distressed assets. They have hotel properties, undeveloped real property. It's not clear what the value of the property is. And the reason is because in 1992 the economy is weak. So the hotel property is either very good or not very good. It's not clear. It's kind of unclear. So you have two assets. You've got the management business, which is very, very profitable. And then you have the property and undeveloped real estate business that may or may not be profitable. We don't know, right, in 1992. The Marriott has a lot of debt. They've borrowed a lot of money from banks and from other lenders. It turns out 25% of the company is owned by the Marriott family. So they have a very, very large stockholder. It's the Marriott family, right? Marriott International is named after the Marriotts, right? It's like, Paris Hilton and the Hilton Hotel. Marriott and the Marriott family. Okay, so this is what it looks like, right? So here's Marriott Corporation. They have a lot of debt. They have the hotel management and food services business, very profitable, 70% of the revenues. And then they have the hotel ownership, the property business. Not clear what the value is. It could be good, it could be bad. Okay? And what they do is this spin-off. Whoops. Okay, what they do is a spin-off. Okay, so they create two companies. There's Host Marriott, which has all the debt and continues to own all the real estate. And remember, this could be valuable or not. It could be very good or very bad. We don't know. And we have the new company, Marriott International. Same shareholders, right? So here it's just one company shareholders. Here it's the same shareholders, but two companies. And Marriott International has the profitable business, and not so much debt. Good? So I've taken this old company, broken it into two, same shareholders, and I've broken the business up. Before, this was all under one company. Now this company has the real estate business. This company has the hotel management and food services business. And most of the debt is with the old company. So Marriott Corporation becomes Host Marriott, and most of the debt is here. Good? Okay, so let me illustrate what's happening using some very simple numbers. So this is Marriott Corporation. This is the old company. It has two businesses, A and B. A is the hotel management business, very profitable. We will give it a value of 125. B is the real estate business. It could be profitable, it could be bad, we don't know, right? Up or down, we don't know. And this company has 100 in debt. Good? So it's a very simple model, just a very simple illustration. Okay, so the debt has a value of 100. If A is worth 125 and B is worth 25, it means the total value of the company is 150. Debt, we will repay the debt, gets 100. That means there is money left over to give to the shareholders, right? If the assets are equal to 125 and 125, the value of the company is 250, the debt gets 100. Again, anything left over goes to the shareholders. And we will assume, just again for illustration, 50-50 chance. Okay? So 50% chance that it's the company has a value of 150, 50% chance that the company has a value of 250. Good? Okay. In either case, the debt always gets paid. No matter what, debt always gets paid. So equity is worth 100. Why? Well, if there's a 50% chance of the company being worth 150, there's a 50% chance of the company being worth 250. The debt always gets paid. That leaves 100 left over. Makes sense? And this is why the equity always gets 100 in this case. That's how we value the equity. Kamchatka, good? Are you sure? It involves math, which lawyers hate. Good? Are you sure? I can do it again. Right? Oh, I'm sorry? Again. Okay, good. Good. The brave person that says again. Good. Okay? So this is a very simple model of a company. And it says there's 50-50 chance. 50% chance of one value, 50% chance of another value. So there's a 50% chance that B is worth 25, 50% chance that B is worth 125. Right? So if the company, if A is worth 125 and B is worth 25, the company is worth 150. Right? 50% chance the company is worth 150. There's also a 50% chance that A is worth 125, B is 125, that the company is worth 250. So it's probability, 50-50 chance, right? One possibility company is worth 150, one possibility the company is worth 250. We're giving each a 50-50 chance of being the case. Good so far? Okay. Now, in either case, the debt always gets paid. If the company is worth 150, the debt gets 100. They get paid. There's 50 left over. If the company is worth 250, the debt gets 100. Debt gets paid. So in either scenario, the debt always gets paid, right, from the assets of the company. The equity is worth 100. Why? There's a 50% chance, remember, the company is worth 150. There's a 50% chance the company is worth 250. The debt always gets paid. What's left over is 100. And so the equity gets whatever is left over. Better? Better? In other words, we're just simply saying the equity could get more, right? There's a 50% chance the company is worth 250. The equity could get 250 minus 100, 150, right? There's a 50% chance the equity gets less, right? 150 minus 100 is 50. But it's a 50-50 probability based upon the likelihood, 50-50 chance of more or less. The average is 100. Better? Okay. Kamchatka? Good, okay. Now, we've broken the company into two pieces. Okay? Now that we've done our spin-off. Now what do we have? We have the real estate business over in Host Marriott. We have the profitable hotel management and food business in Marriott International. All the debt is here, no debt is here. Right? Basically is what we're talking. Again, this is a very simple model of what Marriott is doing. Okay, so face value of 100. The debt is worth 100. But in fact, the value is not the face value. The real value of the debt has dropped. Before, the debt always was going to get paid. Now the value of the debt is less because there is a risk the debt will not be paid. Why? If asset B is worth 125, the debt gets fully paid. But if asset B is worth only 25, the debt gets only 25. It does not get 100. So there's a 50% chance that the debt is fully paid. There's a 50% chance the debt only gets 25. That means on a weighted average basis, right, on a probability basis, the debt is only worth 62.50. Okay, so before the debt was worth 100, it always got paid. Now, because there's a risk it won't get paid, the debt declines in value. Make sense? Right? There's a 50% chance you won't get your money back. Will you pay 100? No, you're going to pay less, right? Because of the chance you won't get your money back. Okay, so the debt is worth less after the spin-off. The equity is actually worth more, right? So if asset B is worth 125, the equity gets 25, right? So if this value, if the asset is worth 125, the debt gets 100, the equity gets 25. If asset B is worth 25, the debt gets 25, equity gets 0, right? So there's a 50-50 chance equity could be worth 25, equity could be worth 0. Based upon probability, the value is worth 12.5. Here, there's no debt, so all of this money goes to the equity, right? So the shareholders, remember, it's the same shareholders, right? Same shareholders. So in this case, the equity gets 125 plus 12.5, right? It goes up in value. You like this? Okay? So the value of the debt goes from 100 to 62.5. The value of the equity goes to 137.5. So think about this. If you are a debt holder, how happy are you with this? You're a debt holder. How happy are you with this? Really pretty angry, right? Right? Did the board of Marriott do something wrong here? Really? Didn't they? What did they do? They robbed the debt and they gave to the equity.
Yeah, but basically they didn't do nothing.
They robbed the debt. They robbed the debt. They said, debt, give me $36, $38, $38, and here, equity, I'm giving it to you. It's a game? If you're a bondholder, this is not a game. You go home at night, you're crying, you can't eat dinner. This is pretty bad.
No, because that holder, they couldn't give this money from first, or they could take this money before they.
They can't do it. I invested the money. The money is gone. I gave Marriott 100, right? And now it's only worth 62.5. I gave the money. It's done. Standard in Ukraine, yeah. That's what I remember hearing. Well, you could go bankrupt, but they're not. This is not a bankruptcy, right? This company is not doing a bankruptcy, right? What are they doing? Don't forget, by the way, 25% of the equity was owned by the Marriotts, right? So what's happening? They're saying they're taking money from the debt, they're giving it to the equity. 25% of that went to the Marriott family, right? This is a lot of money, by the way. Is this okay? Well, it may, forget ethically. Legally, is it okay? Why? But I'm ripping off the debt.
But now they can have another collection of money from other banks for that.
Yeah, but now if you're a bank, are you going to lend after they've done this?
Depends on the bank.
No, shut up. No. Forget financials. You just ripped off the other lenders. You just stole from the other lenders. You know, yeah, I'll lend you money now. Really? It's not going to happen, right? And so what you're seeing, what the board is doing here is entirely legal. Why? To whom does the board have a fiduciary duty? Is it to the debt? It's for the benefit of the shareholders. They are there to maximize value for the shareholders. Did they succeed? Yes! They did exactly what they're supposed to do. Now, if you're a debt holder, if you're a lender and you know that the value of the company, the purpose of the company, is to benefit the shareholders, are you going to lend money now into this? No, right? So what happens in this case? The stock price goes up. This is the real facts, right? Stock price went up by $200 million. Marriott family very happy, right? They end up $50 million richer simply based on this deal. The debt drops in value by $350 million. The CFO of Marriott, the bondholders are not doing as well as the equity guys, that's for sure. It was quite intentional, quite deliberate to benefit the shareholders at the expense of the debt holders. And so as a result, you see a decline in value, but the equity holders benefit by $200 million. Okay. Now, what's the problem? This is exactly the same problem we looked at when we looked at the period between signing and closing, right? Between signing and closing, I'm the seller, you're the buyer. We've signed a contract. You are worried that I'm going to operate the business to benefit me at your expense, right? Before we signed the contract, I was very careful about this business. Now that we've signed the contract, in my mind, it's your risk because you will buy this business. Or think about the yellow Zhiguli, right? I'm selling you my yellow Zhiguli, right? How much was it? 5,000 grivna. You've signed the contract, right? In my mind, it's your car. I may have possession of the car. I have not given it to you yet. But in my mind, it's your car. And so what will I do? Race in Simskaya at 3 in the morning, right? Right? Are you happy that I am racing in Simskaya at 3 in the morning with your car? No, of course not, right? And covenants fix this. Covenants say don't race the car at 3 in the morning or operate the business as you did before the contract, right? We're trying through contract to change behavior so it does not take value from you and give it to me. Same problem here, right? The lenders gave money to the bank, gave money to the company. They are worried now that the board, the company, will take value from the lenders, take value from the bondholders, and give it to the equity. Exact same problem. And so how do we fix it? In the case of an acquisition agreement, yellow Zhiguli, or a business, it's covenants. In the case of bonds, it's covenants too. So this is the one. Same problem, different scenario, but it's the same solution. And this is why you want to be thinking, right? Whenever you come across a problem where because of the contract you are worried about a change in behavior, covenants will very often be the answer, regardless of whether it is a purchase agreement or a Series A financing or the sale of a yellow Zhiguli. You'll always be worried about this change in behavior, and covenants are the solution. So today, we have covenants that block this from happening, precisely this from happening. Right? After Marriott, the banks and the bondholders all included covenants that said, you cannot restructure the company. Right? Of course, right? If you restructure the company, you must get our approval. Right? And so there are now very standard provisions in contracts in order to block the board of directors of the borrower, whoever it is, from restructuring the company to benefit the shareholders at the expense of the debt holders. Covenants, compliance with the covenants, very easily monitored. These are public companies very often, or if they are private companies, the bank can very carefully check to make sure the covenants are being followed. Right? Good? How this works? It's kind of cool, right? Okay. So just very quickly, right? In the case of Marriott, we're talking about the loan agreement. It's an indenture. It could be a loan agreement. In the case of mergers and acquisitions, it's the acquisition agreement, the purchase. So it's different contracts. In the case of control, we have the equity holders, the board of directors, for the benefit of the equity holders, control the company. In the case of M&A, it's the seller. So we're worried about these guys doing something to benefit themselves at your expense, right? That the seller of the yellow Zhiguli will ride the car at 3 in the morning and it will hurt you. The seller of the business will operate the business in a less good way and it will hurt you. Or in the case of Marriott, the board of directors, the shareholders, will restructure the company to hurt you, the lender, but benefit me. All the same concern. And what do? At the time that Marriott happened, there was no protection. This is why it happened. Today we have covenants. In the case of M&A, you typically have some sort of covenants that give you the ability to either not do the deal, right? The conditions to closing are not satisfied. You went ahead and violated the contract, so I don't have to buy. Or I get money back through the indemnity. And sometimes you get specific performance. It means you can go to the court and say, look, they promised to do this, make them do it. Right? You can tell the court, you can ask the court to specifically force specific performance on the part of the seller. Good. Any questions on covenants? Right? Yes. Pledge agreement, yeah, pledges. Same idea. Yeah, yeah. That's right. So the pledge agreement is actually a UK concept, but it is the same concept as covenants. Yep. What else? Okay.
Not a dramatic cases, except matter made some historical changes to corporate law in the US after, after that case with Mario, something like.
Oh, this happens all the time. There is an entire practice around covenants. When you lend to distressed companies, you spend a lot of time focused on covenants. I used to do a lot of distressed lending. It means that you lend to companies that are in financial difficulty. And when you are a lender, you are really nervous about what the company will do. And so it's very common, based upon experience, based upon mistakes that were made, that you adopt and expand and expand and adopt and change the covenants. So if you talk to different law firms in the United States or different banks, they have their own standard covenant provisions, and it's all based upon their lending experience. So when I was doing this, okay, I'll tell you a funny story. As some of you know, I practiced for about 20 years. And I was for a while the lawyer for Goldman Sachs. Do you know Goldman Sachs? Okay. So I was their distressed debt lawyer. There were two of us that did this. And it meant Goldman Sachs would sometimes lend money to companies that were a little unstable. And I was one of the lawyers that they would call. And one day I received a phone call from the head of their investment banking department. And he said, look, he said, Chuck, we want to hire your firm to represent us in the lowest investment quality debt we have ever made. It was CCC credit. Okay, CCC credit is garbage. It's not even debt, it's just garbage. But they wanted to do this loan because one of the founders of the company was the former president of Goldman Sachs. So they wanted to do this loan. And they asked me to get involved because they needed very, very tough covenants. And I had done a lot of work for them, and they wanted sort of that type of background to be part of the covenant package because they were very worried about this. So I agreed to do it, but it was all based upon prior experience in making loans for Goldman. But at the time, I said to the guy, I said, I'm really happy you called me. I suppose I should be kind of proud. And he said to me, no. He said, actually, we're looking for the toughest asshole we could find, and you're the guy we thought of. It's like, he was a friend of mine. It's okay. He was a friend of mine. Yeah, no, I mean, so there are lots of examples. Marriott is a very famous example because it was so obvious. But this idea that you shape covenants to reflect experience with problems, it's something that happens every day, literally every day. Anything else? Okay, let's talk about next slides. Other provisions. Okay, So let's just quickly do some other provisions. Most of this we've talked about a little bit already, but let me just spend time. So I've talked about conditions to closing. So remember, right, I signed the contract today, but the money is not paid until a week or a month or a year from now, maybe after government approval, third-party approval, after you get the money. This is a typical condition to closing, right? And the way it works is, typically there is a condition to both parties closing the deal, the seller and the buyer, but there are also special conditions for the seller and special conditions for the buyer. So, condition to each party's obligation means that they are obligated, they are required to close the deal if the different requirements are satisfied or waived. You can always waive them. You can always say, I'm not interested. I don't need to worry. Don't worry about it, right? I will give it up. So the idea here is that the different requirements have to be satisfied. In other words, that there is nothing that prevents the deal from happening. There is nothing that will cause any of the transactions to be illegal. That the business can continue in effect. That there's nothing that affects the operation. And this is a condition of both of us. Right? If there's a problem here, you don't have to close, or I don't have to close. Right? We can mutually agree to forget about this, just to disregard and close anyways, but it gives us the option not to close, you or me. So if this transaction violates law, do you want to close? Do I want to close? No. We can agree to close anyways, right, if we decide, but it gives us the option to not close if we choose, right? It's mutual. Then you have obligations on the part of the buyer, right? So you're the buyer, I'm the seller. And what are the requirements? Well, first, the reps and the warranties have to be accurate. We talked about this, right? So you're the buyer, I'm the seller. You want to, before you are obligated to buy, the reps and the warranties have to be accurate. If they're not accurate, do you want to buy? Not interested. Are you going to walk away? This lets you walk away. Right? It says you can walk away. You can forget the condition. You can buy anyways if you want. But this gives you the ability to walk away. Are you going to walk away? Are you going to walk away? So who said that? What? Yeah, you're going to renegotiate the price, typically, right? Right? We've spent all this time on the deal. I don't want you to walk away. The reps and warranties aren't accurate. Okay, you thought it was $1 billion business. It turns out that the reps and warranties aren't accurate. Okay, you can walk away. Let's do $800 million. Let's do $800 million. So we can renegotiate the price. Even though it is set up so that you can walk away, typically we'll renegotiate the price. Now, it turns out I'm selling you my yellow Zhiguli. Okay? 5,000 grivna. Okay? You were really nervous about the windows, so I have representations about and warranties about how good the windows are. You were nervous about the radio. I have warranties about how good the radio is. You're worried about the engine and the tires. I have warranties about the tires. And again, remember, these warranties speak twice. Time the contract is signed, they have to be accurate, and time of the closing, they have to be accurate, or you don't have to buy. Now, what happens if it turns out that there is a little scratch on the tire? At the time you signed, there was no scratch. But now, 1 week later, I come to the closing, and there's a little scratch on the tire. Can you walk away? You shouldn't be allowed to walk away, right? It's minor. And so typically, the reps and warranties have to be materially accurate. Not 100% accurate, but and remember, we don't define material. It means it's significant to the deal. Is the scratch material? No, right? So the reps and warranties have to be materially accurate, and the covenants have to have been satisfied. Yeah?
Basically on this, so if the representations of warranty are materially accurate, but at the same time there is kind of scratch, I cannot negotiate the price.
No, you shouldn't be able to negotiate the price, right? Because, remember, it's just a scratch. Come on, is it really important to you that there's a scratch on the tire? Let me ask you, if it was important to you, if you said, these tires have to be scratchless, what would you do? You'd put it in the warranties. That's right, right? So in the warranties, you simply wanted to say the tires are in good condition. Now there's a scratch. It's not material. So they're in good condition, right? If you said, I want scratchless tires, then if that was really important, you put it in the warranties. Now, there is one other thing about the warranties. Let me ask you. This is a tough one. So we've negotiated the warranties. And you say you want the tires to be in good shape, right? You're the buyer. And what do I say? I say, oh, come on. Really? They're tires. They're tires in Kharkiv. Come on. There's dirt and ice and salt, and they bump along the roads. Really? You want them to be like really good tires? I can't tell you this. Now, what I can tell you is the tires are in all material respects in good shape, right? They are tires. They work. They're not going to break. They're tires. Are you okay with this? Are you telling me that you're insisting that the tires have to be like completely beautiful tires? Like the car is in Miami, Florida, where there is no rain or salt or anything? That's what you're telling me? No, look, I will tell you that the tires are good in all material respects. They're tires. They work. Are you okay with this? I'm sorry?
As a buyer, I would like to see this car as...
You can look at the tire. Look at the tires, kick them, do what you want.
But it's kind of... how long are they working in what condition you're treated?
Sure, I'll give you warranties on this. I have no problem. I'll give you warranties. I will tell you I have had the tires for a year. I will tell you that I have not taken them on some Skya at 3 in the morning, right? And I will tell you the tires are good in all material respects. You okay? You okay? Yeah, sure, why not? Of course you should be, right? Now, we get to the conditions to closing. And the reps and the warranties have to be accurate in all material respects. So think about this. I have told you that the tires are good in all material respects. So we've already qualified, we've already modified the representation with materiality. And now we're saying, for you to close, the representation itself has to be accurate in all material respects. It's materiality and then materiality. It's referred to as double materiality. Let me ask you, if you have materiality, the tires are good in all material respects, and this representation must be accurate in all material respects, what is the likelihood that the warranty will not be accurate? It's very hard to imagine, right? Yeah, it's very hard that it will not be. It's very hard that it will not be accurate at the time of the closing. So what do you do to fix this? This is where you have to be thinking. By the way, when you do, how many of you do trial law? Alternative dispute resolution, litigation, arbitration. Any of you do this? Good. Good, because people that do that business, they're playing checkers. You know checkers, right? You move, I move. You move, I move. You move, I move, okay? This, it's chess. It's chess. You have to be thinking 2 and 3 and 4 moves ahead, right? So we've negotiated about reps and warranties, and you say materiality is fine. Of course it's fine, right? And then I see this in the conditions to closing. Now are you happy with materiality in the reps and the warranties? We're saying that a warranty that the tire is good in all material respects is now materially accurate. It's really hard to break this condition, right? So what you thought was reasonable 5 minutes ago, now it looks kind of unreasonable, right? Okay? So how do you fix this? How do you fix this? Kamchatka, how do we fix this? Right? Well, you could simply delete this and say the reps and the warranties are accurate. Period, right? Materiality is already in the representation itself. You don't need to repeat it. the tires are materially good. That's it. Right? This idea that the representation is materially correct when the representation already has materiality in it, that's too much. So let's just agree the reps and the warranties are true and correct. Forget this language. You could do that. Not all warranties have materiality, though, right? So it could be too strict. Very often you'll see what is called, it's called a materiality scrape. What you say is the reps and the warranties are accurate in all material respects without regard to the materiality qualification. So what we've agreed to before, materiality, now goes away for purposes of whether or not this condition to closing is met. You like this? Right? But the point again, you have to be thinking about the different parts of the contract together, right? We negotiated the warranties. When you're negotiating it, think closing. Think indemnity, because they relate to the other parts of the contract. It's chess. Forget litigation. Okay. And okay, again, the buyer does not have to close the deal if it's going to cause the buyer to conflict with law, right? Is what happens. Okay, seller's obligations, same thing. Reps and the warranties of the buyer, if they have them, have to be accurate. Same question about double materiality. Covenants are satisfied, and again, law is also satisfied. It's parallel between the seller and the buyer. Good? Now, you will sometimes see a provision. This is a very standard kind of concept. It says we do not have to close the deal. Very often it says the buyer does not have to close the deal if there has been a material adverse effect on the business. Okay? In other words, as the buyer, I'm the seller, you are the buyer. As the buyer, you do not have to buy this business if between the signing and the closing something has happened that creates a material adverse effect on the company. It means something that is adverse to the business, the assets, the operations, the condition of the business. Okay? So, if something bad happens, you don't have to close. Well, hold on. You might say, look, as the buyer, it's not a question of whether something bad has happened. It's a question of whether something bad has happened or reasonably could be expected to happen. Right? In other words, between the signing and the closing, something may have occurred where the results haven't happened yet. So nothing bad has happened yet, but reasonably they are expected to have an adverse effect on the company. Right? In that case, you shouldn't close either. Right? Even though the loss has not happened yet, the bad thing happened, it's a material adverse effect, you don't have to close. Or maybe you simply renegotiate the price. Good? The problem is, it's not just simply limited to the business. It could also be some sort of event that affects the seller's ability to close the deal or the buyer's ability to operate the facility. So we're expanding out what material adverse effect is. So think about it, right? You're the buyer, I am the seller. Let me ask you, who is more likely to know about some sort of bad event that could occur that will affect the assets, the seller or the buyer? Seller. No, who said the buyer? Shout out buyer. Who's buyer? You're the buyer? Why buyer? Yeah, he's interested to know, but who knows more about the business itself?
Who is operating it?
About the business? Seller knows it, right? Yeah. Of course the buyer wants to know more, right? But the seller right now has more knowledge, right? And so what we're saying is, buyer, you don't have to close if there's something that happens that has or could reasonably be expected to have an effect on the business. Again, I more likely as the seller know about this, right? If there's a real risk, this language means I will talk to you about this, right? In other words, as the seller, if I know something, if I'm trying to hide something, right? If I know something, because of this language, if it happens, if it becomes clear that there's a problem, you don't have to buy. And if you don't buy, we'll renegotiate the price, right? So if it affects the business, or who knows more about, will there be a change that affects my ability to close, seller or buyer? Me, right? The seller. Who knows more about whether or not the operation of the facility will continue in the way it has in the past going forward? Who knows more about the likelihood of operation, seller or buyer? Seller in all cases. So these are all things that the seller reasonably knows, right? Because I'm operating the business that you don't know as much about. And so I agree, you don't have to close, right? You don't have to close in the event that there is some bad thing that happens that I know about that affects the value of the business to you. Good so far? But I don't know everything, do I? Right? I know about my operations. I know about how I run the facility. I know about the effect on me, of my business. But I don't know about acts of God. So, as far as changes in economic conditions, general economic conditions, changes in markets, war or sabotage, changes in law, changes in accounting, changes in actions required by this agreement or announcement of the transaction, I don't know what the effects of this will be, right? Maybe we know this equally, but I certainly have no special knowledge of this. So, because I have no special knowledge of this, should I take responsibility? Right? For this I should. These are all things that I have knowledge of. Right? Again, this is all information. These are all things that I have knowledge of. For this, I have no special knowledge. Or if I have knowledge of this, you and I have the same knowledge. Right? It's general economic conditions, war, sabotage, changes in law. Okay? So, in this scenario, you should be allowed to walk away or renegotiate the price. But if it's some sort of act of God or significant change that neither of us has special knowledge of, it means we're not going to let you walk away. This is an exception. It's something that you cannot walk away from. Good so far? So in other words, if there's an act of sabotage that affects the business, you can't walk away. Right? If there is a change in law or accounting that affects the business, you cannot walk away. If it's something else, though, right, that results in a change in the business, something not covered here that results in the change in the business, you can walk away. Make sense? Oh, we're not done yet, right? Because, you know what? It's true, I do not know about changes in law or changes in accounting or changes in economic conditions. But I do know if my business has some special effect, there's some special effect on my business if one of these changes occurs. In other words, I cannot predict whether the economy will change. I cannot predict whether law will change. I cannot predict whether sabotage will occur. But I do know that if sabotage happens, or if the economy changes, or laws change, I will know if the effect will be greater on my business than on businesses generally. I'll know about a particular sensitivity, right? Maybe my business, there's something unusual about it. And so change in law affects everybody. Changes in economy affects everybody. No special knowledge. But I do know that if there's a change in the economy, it will have a special effect on me. So I should take responsibility for that, right? So we say, if it is an act of God, neither of us, you cannot walk away. Neither of us is responsible. However, if it's an act of God that involves either a change in economic conditions or changes generally in the industry, and if it affects me disproportionately, in other words, it has a greater effect on me than the rest of the industry, well, then you can walk away, because I have knowledge. This is all forcing knowledge. Isn't it interesting, huh? Right? It's all forcing knowledge. Okay, so you'll sometimes see this very long language. This is very common long language in agreements. And now you know, it looks as if we are simply transferring risk. What we are really doing is forcing knowledge sharing. If I know of this problem, I'll tell you. Right? Of course I'll tell you. If I don't tell you, right, it means you'll have the ability to walk away. Make sense? Okay. What else? Limitation on warranty. Very common. You'll see this in a lot of technology agreements. You take the technology as is where is. In other words, I make no specific representations about the quality or whether or not this particular asset is good for your purposes. You take it as is where is. So whatever it is, you take it. I make no special additional warranties. Very common in technology agreements. Seller makes no representations or warranties or any statement whatsoever with respect to the assets. Right. Again, you take it as is where is. Very, very common language in technology agreements. You'll also see them in like asset agreements, like sales of the yellow gigoli. Right? Unless I tell you otherwise, maybe I give you an express warranty. Tires are good, window is good, business is good. Unless I tell you specifically, you take the business as is where is. Good? Termination of the agreement. We can always terminate the agreement. So we might agree to terminate the contract. You can either agree to terminate it together. Very often in acquisition agreements, there is what is called a drop-dead date, a date by which the deal must happen. If it does not happen by this date, it means there's something wrong. And so the deal also terminates if it is not closed before some date, the termination date, very often. And of course, if there is a breach of a rep or a warranty, so I am the seller, I breach the rep or warranty, you tell me it's been breached, and I cannot cure it, or I refuse to fix it, well then you can also terminate. Right? More likely you will renegotiate the price, is what will happen. Good? The indemnity. So, let's talk about the indemnity. The indemnity typically covers claims, losses, damages, liabilities that relate to reps, warranties, or covenants, or seller's operation of the assets prior to closing. So breach of reps, warranties, or covenants. So let me ask you, under Ukrainian law, forget U.S. law, under Ukrainian law, if I enter into a contract with you and I have a warranty, a guarantee, or I have a contractual agreement, I covenant, I will do this, I will do that, and if I fail to do this, if I break the guarantee, if I fail to do what I agree, can you sue me? You can sue me for your losses, right? If you suffer losses, you can sue me. Same in America. Why do we have this? It's just saying, right? Seller agrees to indemnify and hold the buyer harmless and others against losses, claims, damages, liabilities that relate to breach of rep, warranty, or covenant. Done. Why do I have this language? It's kind of stupid, right? These provisions are really long. They get negotiated heavily. Are they there simply because lawyers want to generate more fees? They want to look important? Oh, look, we're negotiating the indemnity. Why is it here?
Because this happens in reality.
Well, I understand, but why can't I just sue in contract? Right? Same thing for the buyer, right? Buyer also gives an indemnity. Any inaccuracy or reps and warranties or buyer's operation after the closing, right? We're selling the business. So you're responsible before the closing as the seller. I'm responsible after the closing as the buyer. And we both agree, right? Breach of reps, warranties, or covenants, right? We are responsible for. We will pay for your damages. Why? What are we doing here? Now, many young lawyers look at this and they say, well, this is the way in which I can sue. No. You quickly forget law school, don't you? No, you can sue under contract. So why is it here? Well, sometimes you will see language like this in an agreement. And what it says is that except for fraud, the indemnity, this is what this is, the indemnity is the sole and exclusive remedy of the parties. In other words, we agree to waive any other remedy to which we are entitled. So you have to read the indemnity with this. You cannot read the indemnity by itself. So what does it say? It says, look, we agree, seller and buyer, that any rights you have under contract, you give up. Your only rights are the rights that are set out in the contract, specifically in the indemnity. So in fact, what we are doing is narrowing your remedies. Under law, your remedies are to sue in contract, right? Whatever that means. Now I'm saying you waive those remedies. You give them up, and your remedy is now limited to the indemnity. Okay, but if the indemnity covers losses, maybe I don't care. Looks like it's the same, right? Why do I care? Well, very often we have what's called a survival period. And what it says is that the reps and warranties and the indemnity only survive for a period of time. Usually the period of time is less than the period of time provided under law. So I think in Ukraine, if you have a breach of contract, you can sue for 3 years, is that right? 3 years? So, do you think this language is going to say 3 years? Nah, it says 1 year, 2 years, right? And so in fact, what you're doing, it's a trick. Don't be taken by this trick, right? It looks as if I am giving you the ability to sue. What I'm actually doing is limiting your ability to sue by lowering the time period from 3 years down to 2 years or 1 year or whatever, right? Because this is the exclusive remedy. No claim for indemnity may be asserted after the survival date. After that date, you agree, you cannot sue me in contract, you can only sue me in indemnity, right? You've waived your other rights, and you also agree you cannot sue me for indemnity after some date, 1 year, 2 years, something less than the 3 years provided by law. Good? In addition, very often you have an adjustment in damages. So if you sue under contract, I broke the agreement, I broke the warranty, I broke the covenant, you will sue me for your losses, right? What we will often do in the indemnity is we will also limit damages. So number one, I will limit the ability for you to sue. You cannot sue me for 3 years, now it's just 2 years or 1 year. Sometimes the indemnity has a procedure that you must follow. If you sue, you must do A, B, C, D, things that are not otherwise required by law. And in addition, I will limit the damages. So very often, there will be a deductible. What it says is look, I don't want you suing me for every grivna that you lose, right? It may be the case that you lose a little money here, a little money there. I don't want to worry about this. We will agree you will only sue me if you have damages in excess of the deductible, in this case, $3 million, right? So another way of saying it is you will sue me for, if there is $999,999, you get zero, right? If there is $3,001,001, you get $1. Okay? In other words, the first $3 million, it's small, right? If it's something in excess of $3 million, well, then I'll pay you. But that first $3 million, no, it's gone, right? I will pay you only the amount by which losses exceed $3 million, right? So under contract, you could sue me for the full $3 million. You could sue me for $2.9 million. But because we've agreed the indemnity is your exclusive remedy, you can only sue me if the amount exceeds $3 million, and then you only get the difference above $3 million, right, is one possibility. The second is called the first dollar. It's a threshold. So it's a little different. It says, look, I will indemnify you for losses, the full amount of losses, only if it's above a threshold. Usually the number is higher than the deductible, so $5 million. So in other words, if there's $4,999,999, you get nothing. If there's $5,001,001, you get $5,001 in this case, right, in the second case, right? So it's a threshold above which you get the full amount. And sometimes you get a combination, right? It says, look, if the amount is in excess of $5 million, I will indemnify you, but only for amounts in excess of $3 million, right? So we are combining this, and we have it down here. So if the value of the losses is $4,999,999, you get Nothing. Okay? If it's 5,000,001, you get 5,000,001 minus 3,000,000, you get $2,000,001. Okay, is how this works. So what are we doing? We're adjusting the damages in a way that otherwise under contract law you don't have the ability to do. So don't be fooled by the indemnity. The indemnity looks like a way to sue. Nah, it's a way to narrow the lawsuits. Good? Okay. Questions on this?
Basically, it can be also other different other different provision in indemnity which also will narrow down the suits in any other ways. Yeah.
Yes. So there are sometimes procedures and other things too. These are some standard ones. Yeah. But yeah, the indemnity is basically, typically it is not expanding. Typically it is narrowing the scope of lawsuit from what is otherwise permitted under law.
Is it possible to break these indemnities in the court?
Well, you can try. Sometimes the argument is the indemnity, because it limits my rights under law, it's void against public policy. And so the argument then has to be, what is the overriding policy interest? Sometimes in cases involving stock issuances, the view is there is an overriding general interest in reps and warranties being accurate, and so you cannot narrow it through the indemnity. And so the U.S. financial regulator always takes the view indemnities are void. It's never been fully tested in court. So yes, you can try to make the argument that it's void as a policy matter, or maybe you argue, in the UK, it's a true story. I did another deal. It was one of the last deals I did in practice before I became a professor. And these guys really made me angry. I don't remember why, but I was really angry. And it was supposed to be a 2-hour negotiation. It became like an 8-hour negotiation. And the reason is the lawyers on the other side never listened to my lectures. And so they argued really hard on reps and warranties, and I gave it up and gave it up and gave it up and gave it up. I was the seller, they were the buyer, and I got it all back in the closing conditions, and I got it all back in the indemnity. It's chess, right? And so I gave up all of these things in the warranties, and then I said, but you can't sue me. I narrowed the indemnity. Couldn't sue me for anything, okay? This particular contract was governed by English law. I'm not an English lawyer, so I had a friend of mine in the room. It's a firm called Slaughter and May. It's a very, very good corporate law firm. And a friend of mine is a partner, and he was sitting in the back. If you're English and you are from a big law firm and you are not negotiating, what do? You drink tea. So he's drinking tea in the back, okay? And the deal is done, and he was reading the documents, and the next day when we were about to sign, he called me and he said, look, come over about an hour early. And I went over an hour early. He said, look, we looked at these provisions. He says, you really beat these guys. I said, yeah, they were jerks. And he said, the problem is we don't think this document is enforceable in the UK. It's too one-sided. They said it's considered to be too overreaching. And I said, yes, we have the same concept in America, but it only applies if you're negotiating with grandmothers and orphans. I mean, inexperienced people. And these guys had 4 lawyers negotiating. And he said, yeah, not in the UK. In the UK, apparently, the concept applies even with institutions. So we had to give back provisions. It's very strange to walk in the room and say, we'll give it back. So yeah, so there also are questions of enforceability if it's too one-sided in the UK. In the US, it's more of a policy question, public policy question. Good? Okay, let's talk about choice of entity. How are we doing on time? Yeah, we're good. Okay, so we'll continue to talk about choice of entity. So this is a little bit more of a US discussion, but it's useful to know for some of you may do work in the US, so you want to know this. Some of you will do work here in Ukraine, and you'll have at least some sense of what we do in the United States. So the question is, what sort of entity should I use when I'm creating a startup? So let me start by saying, there is a website called Cooley.go. Cooley is a major US law firm. they provide standard documents for free. They are really good documents. Some of the documents that I think Olga gave you come from Cooley.go. Not all of them, but some of them do. And so it's a really good website. In fact, they even have for some of the documents an automated system. You just plug in some names and boom, it kicks out automatically. So you don't even need to worry about filling it in yourself. They will just generate it for you automatically for free. Why do they do this? Because there's not a lot of money in these documents. They're very standard, and then you love them, right? And you will maybe hire them in the future, is why they do. So I would recommend that you look at this, Cooley.go. It's a great website, and it gives you a lot of information about startup business in the U.S. Okay, so where do you organize? If you're going to create a company in America, where do you do it? What state? So in the United States, when you create entities, sorry, New York? Nah. Sorry? Delaware. Okay, yes.
Texas.
Forget Texas. No, God, no. Not Texas. Nevada? Nah. Nevada, we'll come to that. Nevada was known for LLCs. Florida, not so much. No. Really, it's Delaware. It's Delaware. There you go. Delaware. Okay. Now, just so you know, this little thing here is Delaware. Okay? It is, I mean, if you drive through Delaware and you sneeze, you will miss the state. It is very small. They make a lot of money through having laws that are useful for incorporation, for creation of entities. They make a lot of, depending on the year, 20 to 25% of the state budget from taxes come from creating entities. So they have a strong economic incentive to be very good at this, to have laws that are very current, that are easy to use, that are clear, and they are very, very active in this area. So it's very small, but they are, in terms of the corporate world, they are the dominant world in the United States. Over 50% of the Fortune 500 incorporated in Delaware. Over 70 or 80% of the Fortune 100, biggest 100 companies in America, incorporated in Delaware, right? So they make a lot of money this way. Okay, so why Delaware, right? Well, principal reason why Delaware is important for venture capital firms is, for companies, is venture capital firms want you to go to Delaware. Investors prefer Delaware. And the reason they prefer Delaware is because the laws are very clear, very well developed. The cases, the court law is also very well developed. And so as a result, investors, and for that matter, company executives have greater certainty. You know what the law is. There is no question what is the law in Delaware compared to Texas or Florida or Nevada. The law is very, very clear. And that's because, remember, Delaware has a strong incentive to have good laws. They want to attract business to incorporate there. So they are constantly updating. Every summer, so it's very funny. I teach, corporate law in the United States. Every summer while my students are getting suntans, the Delaware legislature puts out new laws. It's just terrible. July or August every year. So every year, July or August, I must come in off the beach and read these new laws because they are constantly updating them. But they are doing it in order to stay current. And the venture capital firms like this. Investors, lawyers, for the reasons above, tell the venture capital firms, insist that the entities that you invest in be Delaware firms. There are also administrative benefits, right? The government is very, very easy to work with. That's the Secretary of State in Delaware. And there are lots of businesses in Delaware that are there to support tech startups, right? So Delaware is the obvious choice. And if you're going to raise U.S. venture capital money with a U.S. entity, Delaware is the place to go. Okay. Now, there are many different types of entities in the United States. Limited liability partnerships, limited partnerships, statutory trusts, and so forth. We'll focus on three. So the three main options are what's called a C corporation, an S corporation, or a limited liability company, an LLC. Those are the three we'll focus on. And that's because those are the three that venture capital firms tend to focus the most on. And so we've got the three entities: C corporation, S corporation, LLC. No reason to read all this stuff. The point is that they all have limited liability, right? It means that you don't have to worry about someone suing to get your home. You have limited liability in the entity. However, C corporations do not have what's called flow-through taxation. We'll talk about this in a moment. S corporations have a tax benefit. LLCs have a tax benefit. C corporations do not. So you've got C corporations not preferred from a tax standpoint. Again, we'll talk about that in a moment. In terms of managing the company, LLCs can be a little difficult to manage. And that's because they're heavy, big contracts. And so to set them up, to manage them on a going forward basis can be a little difficult. Corporations are easier. There are some other tax benefits. We'll talk about that, tax issues. And we'll also talk about employee benefits. So we'll come back to these other points in a moment. So, limited liability, right? All three entities have limited liability. The ability to limit the shareholders so that you cannot sue them directly, right? That they are simply limited in terms of their exposure to the capital they've invested in the company. There is one exception called piercing the veil. I don't think this exists in Ukraine, does it? Alter ego or piercing the veil? It's where you can disregard the entity and get the shareholders? Yeah. So in the US, we have this concept where the corporation is being used in a way that abuses, that mistreats in a way that is inappropriate. It's not fraud necessarily. It could be where the company is not run to be a profitable company, where the company is not run for the benefit of the stakeholders, it's run for my own personal benefit. In these cases, the limited liability of the company is viewed as being inappropriate, right? It's not something that is equitable. It's not fair to the creditors. And so in this it's very narrow, maybe less than 1% of the cases, you can disregard the corporate entity and sue the shareholders directly. It's called piercing the veil or alter ego. So if you do not observe the formalities, if you don't, for example, treat the company as a separate company, you don't have board meetings, if you keep all the money together, your personal money and the company money are kept in a single bank account, if you keep single records, if you work as if the entity is not separate, if you fail to properly invest in this company. These are all ways in which courts will step in, disregard limited liability, and permit you to get the shareholders. Another way of saying it is creditors can be hurt by limited liability, right? If you're a creditor, if you're a lender, it means you are only limited to the assets in the company. But what if the company is being run inappropriately, in a way that really, really favors the equity and really hurts the debt holders? In this case, you can sue and go after the shareholders' assets. But it's very exceptional, right? It's a very, very limited case. I will tell you, I get brought in as an expert witness in these cases. So I will go to trial on these cases. It's very hard to pierce the veil. It happens sometimes. We did it once. But it's very hard to pierce the veil. Good? Okay. However, so all three have limited liability. However, the tax issues are different. So many venture capital firms will not invest in what is called a flow-through tax entity. A flow-through tax entity means that you are not taxable at the entity level, right? So here's my entity. Here is my investor. Damn. Okay, one more. There you go. Okay, so here's my entity. Normally, if I was going to be taxed on any revenues, any profits, I'd be taxed here. And then if there's a dividend, I am taxed here, right? Double taxation. In the case of a flow-through entity, you are not taxed here, right? So in other words, there's a single tax. It's tax efficient. It means that you will flow the revenues or the losses, right? The income or the losses up to the shareholder level, and then the tax treatment is simply handled at the single level. So I avoid double taxation, right? If it's not flow through, I am taxed here, it's greater tax. If it's flow through, I'm simply taxed up at the entity level. Most venture capital firms will not invest in a flow through vehicle. They are very nervous about investing in flow through vehicles. And the reason is because for U.S. federal tax purposes, they end up being, the income or the losses in this company end up being treated as income or losses in this investor. And they don't like this. We'll explain in a moment. In addition, non-U.S. investors also do not like to invest in flow-through vehicles, even if there's losses. So if you're a Ukrainian investor and you invest in this flow-through vehicle, remember, the gains and losses here are treated as your gains and losses. What does it mean? Even if there are no gains, you are a taxable person in the United States. Do you want to disclose your financials to the U.S. government? Not so much, right? So venture capital firms don't like flow-through. We'll see why in a moment. And foreign investors don't like it either. And so as a result, venture capital investors in the United States do not like flow-through vehicles. Okay, so for our purposes, we're going to look at an LLC or an S corporation. Okay, LLCs are flow-through vehicles. S corporations are flow-through vehicles. However, S corporation, we'll forget a moment. S corporation also is good from a tax perspective, right? In the case of an S corporation, you do not tax it at this level. The problem with an S corporation, to get the tax benefit, all the investors have to be natural persons. It means a company cannot invest in an S corporation. Okay? Venture capital firms are companies. They're not natural people. So if you use an S corporation, it means that no one's going to invest. So if you're thinking about pass-through vehicles, even though technically it's S corporations and LLCs, in the tech world, in the VC world, it's really just LLCs, right? S corporations don't make sense. And so we're really talking about LLCs. Good? Okay. So here is a typical venture capital fund. Whoops. Here's a typical venture capital fund. So the fund is itself usually a limited partnership. Usually the fund itself is a flow-through entity. So the fund invests in a startup. Okay, so this is the new tech startup. The venture capital fund invests in the startup, and we have three different types of investors, right? We have the teacher's pension fund, which is a tax-exempt fund in the United States. We have a non-U.S. investor, and then we have a U.S. high net worth individual investor. Okay, so keep in mind, right? This is a typical structure for a venture capital fund. The fund itself is a flow-through vehicle. It means that any taxes here, if they are flow through to here, or any taxable income flows through to here, which then flows up here. So there's only a single taxation here, right? We don't tax it here, we don't tax it here. So it's very tax efficient. You might say, oh, it looks really good, right? If it's not a flow through, then I tax it here, I tax it here, and I tax it here. But if it's flow through, no tax, I simply tax it here, sounds pretty good, right? And so you might say, from a tax standpoint, I should invest in flow through vehicles. Maybe that's why an LLC should look good. But let's focus for a moment. Teacher's pension fund is a tax-exempt entity in the United States. It is tax-exempt only for certain types of income. If there is unrelated business taxable income, in other words, if there is income not tied to their core business, then the teacher's fund loses its tax exemption on that income, and it gets taxed at the highest rate, at the highest corporate rate on the income. Okay, so UBTI, right, unrelated business taxable income, this is income that is not substantially related to the core operations, in this case of the teacher's fund. So let's say that my company invests in unmanned drones for transportation between Kiev and Kharkiv, let's say, right? And it generates revenue, income. Is the operation of unmanned aircraft between Kharkiv and Kiev, is that related to what the teacher's pension fund is doing? No. Because the income is passed all the way up here, it is traded as unrelated business taxable income. It means it is taxed at the highest rate up here. So in fact, it becomes very unattractive, right, to the teacher's pension fund. If this is a flow-through, this is always a flow-through, then this entity, if it's a flow-through, it means that this entity now gets taxed on that income at a very, very high rate. Make sense? Okay? So for tax-exempt investors in a venture capital fund, flow-through vehicle like an LLC is not interesting. Okay? Whether it's an S-corp or an LLC, it's not interesting. Okay. The other problem is ECI, effectively connected income. A non-U.S. person, right, our second limited partner here, a non-U.S. person is subject to federal income tax on income or losses effectively connected with business in the U.S. So again, this is our startup. It's in Delaware, involved in unmanned flight, right? This is our investor. There are gains or losses here, but remember, it's not taxable here. It's not taxable here. It's now taxable here. This is income, even though he is simply an investor, that is effectively connected to the United States. It means that now he is subject to U.S. tax. Okay? How many Ukrainian investors, even if there are losses, want to tell the U.S. tax authorities, hey, here's my income and here's my bank account, here's who I am? Nobody. Right? Nobody wants this. So for both of these reasons, it makes no sense for this to be a flow-through vehicle. Right? In other words, if you are planning to get venture capital money, this is not going to be an S corporation, because S corporations, you can only have natural people invest. LLC is a tax-through vehicle, but it's complicated to operate. And LLCs also are pass-throughs. Neither of these investors want this. So very often, it is a C corporation. It is taxable. You might say to yourself, it looks like it is the least efficient as a tax matter, but because of the flow-through arrangement, it's actually the most efficient. Interesting, huh? The truth is, too, most startups don't make a lot of money. Right? They just don't make a lot of money. And so you don't worry about taxes. Let me state it differently. If you end up in a scenario as a startup where you have so much money you worry about taxes, congratulations. That's a good thing, right? Otherwise, you are worried about this flow-through problem. And this is why most U.S. venture capital funds, if you organize as an S-corp or an LLC, U.S. venture capital funds will tell you, change it. It can be very expensive to change. So it's better unless you... Now, this guy might be okay with a pass-through, high net worth individual, right? I'm in the United States anyways. I'm subject to tax, so this doesn't matter. And I'm taxable, so this doesn't matter. So maybe I want the pass-through, right? If there's income here, it flows through here, it's just taxable once. If there are losses here, I can offset against my gain. This is good, right? It's as if this is really good. So if all my investors are U.S. high net worth individuals, maybe LLC makes sense. S-corp still doesn't make sense because it's an entity, but maybe an LLC makes sense. But in most cases, that's not the case. A lot of money comes in from teachers' pension fund, from tax-exempt entities or foreign investors. And so typically, venture capital firms will tell you, do not do it as an S-corp or an LLC, organized as a C corporation, right? A taxable entity, which sounds tax inefficient, but actually it's the best option. Good? Good. Okay. In addition, there are also issues with employees, right? Very often in startups, employees receive stock options, right? They receive equity in the company. With an LLC, it can be very difficult to issue equity awards. And part of the reason for that is the way the LLC law operates. Typically, when we're talking about an LLC, it's very easy to issue interests in the LLC that are economic interests. But voting and control interests, more complex. You can do it, it's just more complicated. And so as a result, you don't really have stock options. You're able to issue what are called profits interests, interests in the profits of the company, but not really voting rights, full control. And so most employees don't like this, right? To be honest, it's too confusing for them. They say, look, my friend got stock options, his grandmother got stock options, my brother got stock options. What is this profit interest stuff? I don't know what it means. So it can be very confusing for employees. C corporations, which are taxable, do issue stock options, and employees generally understand it, right? Again, some employees may prefer LLCs. Why? Because they are high net worth individuals, and so it's the most tax efficient for them. Most of your employees are not going to be high net worth individuals. They're going to be young people that are just starting out. They don't care about tax planning. They just want to get the same thing that their friend and their brother and their cousin got, and that's usually stock options, not LLC interests. So on balance, it's typically, from an employee perspective, it's typically C corporations are also favored. Good? Okay, what else? Many of you will not organize in the U.S., but if you do, you will become familiar with what's called an 83B election. Okay, this is an election under the tax laws. And what it does is it permits you to pay the taxes on the value of any difference between the grant price and consideration paid at ordinary income tax rates up front and not worry about capital gains. I'll show you what this means in a moment. But basically it says I can pay taxes at the time of the grant of the stock option at the very beginning. As the value of the stock option goes up, I pay nothing until eventually the company is sold or there's some other way in which I get value for my stock. So what is it? So let's do an example. We have a brand new company with 2 founders. Each founder is given 1,000 shares, 2-year vesting. Do you know what vesting is? Vesting? So vesting means I'm going to give you 1,000 shares, but you don't have the rights to the 1,000 up front. You will get 1,000 shares, but I will give you 500 in 1 year and 500 at the end of 2 years. Why? Why do I do this? Why do I vest stock? Why not just give you the 1,000 shares? Yeah, I'm a nice guy. You might sell the shares, but you want to sell the shares, don't you? Whether I give you 1,000 shares up front or whether I give you 500 and 500, eventually you want to sell the shares. If I was worried about selling the shares, I could always agree by contract, a covenant, that you agree not to sell the shares. We could always do that.
Maybe you're going to make some more shares.
I might, but again, I'm agreeing to give you 1,000 shares. You're going to get 1,000 shares.
When I got 1,000 shares, I'm get more shares, 15%.
Okay, so, well, that's fine, but we can agree I will give you 1,000 shares, and I will increase the amount if I issue more shares. I could do that too. Why not just give it to you all at once? Here, 1,000 shares, thank you, goodbye. Sorry? No, we'll see, taxes can be fixed. Why not just give you, why do vesting? Right, vesting in the United States typically happens over 3 to 5 years. Here, I did it 2 years because 3 years makes it too long. So it's just 2 years. But typically in the U.S., it's 3 to 5 years. Right? It means if I give you 1,000 shares, it means that you will get if it's 5 years, you will get 200, then 200, then 200, then 200. You will not get the full 1,000 up front. Why? Why would I do this? I'm just a terrible guy? Why? Very common to do this in startups, to do vesting, right? In other words, you know you will get 1,000 shares. You're just not going to get it for 5 years. But you might sell it anyways. You could sell it. But no, I give these to you. These are stock options, right? This is it. So when you join a startup, do you have a lot of money? Is there a lot of money in a startup? Is there a lot of money in a startup? Not so much money in a startup, right? So why do you join a startup? To make money, I hope, right? But I mean, you could go, if you could go and work for this company or that company. You could go work for McDonald's, right? Why did you join the startup?
To learn the value of this company.
Yeah, you want to create value in the company. And you want to share in the value of the company, right? Well, company doesn't have a lot of cash now. How do you share in the value? You get stock. Right? If this company is Facebook, do you know the secretaries, the receptionist at Facebook, multimillionaire? Why? Because the receptionist was the receptionist before Facebook became a public company. She showed up and they said, look, I'm sorry, I cannot pay you the 20 grivna an hour you would get or whatever, right? I can't give this to you. I'll give you stock. Oh, okay, I'll take stock. Now she's a multimillionaire, right? The receptionist drives to work in a Mercedes. Maybe someone drives her, I don't know, but she's a multimillionaire, right? So the idea to get stock is to get part of the value. You want to create the value and realize the value. Okay, so I'm going to give you stock, right? It's part of your compensation. I'm giving it to you. I can't give you cash. I don't have a lot of cash. I'll give you a little cash, right? Because you have to keep the lights on and buy food. But I can't give you a lot of cash. Most of the value is in the stock. By the way, we talked about, information a few moments ago. Why else am I giving you stock? Well, intellectual property is property in the company. Why am I giving you stock? I'm sorry? Motivation, yeah, right? I'm giving you stock so that you work hard, right? If I just simply gave you cash, you'd go home, right? Yeah, 5 o'clock, I'm going to go home. Now I say, you know what? I give you a little cash, right? I'm giving you a lot of stock. So two things. Number one, I have a little cash, so I can't go to the movies, right? But secondly, you've given me stock. And if I work hard and I do a good job, that stock could be worth the next Facebook. It's motivation, right? It's a way, because of the informational difference, I don't know what's in your head. Will you work hard or not work? I'll give you stock. It causes you to work really hard. Okay, so why not just give you all the stock up front?
Just to motivate so that employees would trigger and open the company's capital, and so both would win, the founders and the employees there.
Yeah, but if I give you 1,000 shares today, same thing, isn't it? If I give you 1,000 shares today, so here we're talking about vesting. I will give you 1,000 shares over 5 years, 2, 2, 2, 2, 2, or 5 and 5. Why not just give you 1,000 shares today? Same thing, right? Let me ask you, if I give you 200 shares today and you quit next year, do you get 200 shares in the second year? No, right? I give you stock over some period of time, also for motivation, but to stay with the company. If I give you 1,000 shares now and you go away, you have the 1,000 shares. I would rather give you some cash and say, look, if you stay with me 1, 2, 3, 4, 5 years, then you get the 1,000 shares. So it's a way to motivate and keep you focused on the company. If you leave to go work for someone else, you lose your stock options. Good? Okay. It could. Yeah, it can be in the contract, but again, there's work and there's work, right? And so I signed the contract to work for you for 5 years. First, can I break the contract? Sure, I can break the contract, right? Secondly, even if I don't break the contract, if I show up and drink coffee all day, right, doesn't really help the company. So equity, motivation, keeping you with the company, motivation, all part of stock and the vesting process. Make sense? Okay. So it's so in this case, each founder is granted 1,000 shares, 2-year vesting. The price per share is very low. It's 1 cent a share. Company just started, no value. Income tax rate is 33%. Capital gains is 20%. Capital gains means tax on increases in the value of the stock, right? Increases in the value of the stock. Okay. So if I do nothing, the grant, the options are granted. Founder pays no tax because it's the grant. There's no vesting in this case, right? I don't have the stock. There's just simply the company says you will get 1,000 shares, doesn't actually give it to me. End of year 1, company value is $10 a share. It means I'm going to pay tax on 500 shares, 50% of the 1,000 shares, $10 a share. Liability is $16.50, right? This is a tax rate of 33%, 500 shares, value of $10 a share, right? And so I pay tax, $16.50. End of year 2, value is 100. I pay tax again. End of year 2.5, we sell the company. I pay additional, now capital gains tax. My total tax is $40,000. Okay, in this case. Let me ask you, there is one problem. Just think about it. Company is worth $10 a share. You're not selling the company yet. You're going to sell the company down here. $10 a share, but you're being taxed at $16.50. Do you have the money? No, it's a real problem. You have paper value, but not cash value. And so if you do nothing, you have taxes that you have to pay, right, as the grants are vested, and amounts that you must pay in cash where you do not necessarily have the cash. You have the paper value, not the cash value. Okay? Now you do the 83B election instead. Now under the 83B election, you pay all your tax in the very beginning. But remember, stock is worth nothing. I pay 33% tax on a company that is only worth 1 cent a share. I pay $3.30. I pay no additional tax, right? 0 and 0. So my total tax is $3.30, right? Up until the time that we sell the company, and then I realize capital gains on my 1,000 shares. So what does it mean? It means the taxes are very low. Do you have $3? Yes, as opposed to $1,600. And secondly, the tax amount itself is actually lower. Now, this makes sense if you expect the company to increase in value, right? If you expect the company it starts low and will increase in value, then 83B election makes sense, right? If you expect the company to start at a great value and then lose money, then doing nothing makes sense, right? And the reason is because if you do the 83B election, you get taxed in the very beginning. So if it's high value here and you expect to lose money, don't do the 83B. How many startup guys expect to lose money? Nobody, right? And so almost everybody will do the 83B election. Make sense? Ukraine should think about this. It is a tax-preferred way of incentivizing entrepreneurship. It recognizes that entrepreneurs don't have cash, and it still means that there's going to be taxable income when the company is sold and there's cash. It's just a lower amount, and it avoids this problem where there is income tax in cash that is payable when I don't actually have cash. Make sense? Okay. The other thing is something called a QSBS, Qualified Small Business Stock. LLCs are not eligible for what is called a QSBS. Why is this important? Because if you hold QSBS stock for 5 years, all of the gain is not subject to tax. There is no capital gains tax. Okay? To get the QSBS benefit, it must be a C corporation. It cannot have more than $50 million in assets. You buy the stock originally from the company, and at least all of the 80% of the value comes from the active conduct of a qualified business. Almost all tech startups meet this requirement. Okay, so if you want to, after 5 years, avoid all capital gains, it means it cannot be an LLC, it must be a C corporation, and you buy the stock from the company, or you get it as part of a stock option from the company. It means that you avoid capital gains tax. Okay, so will you ever do an LLC? No. Almost never, right? VCs will push you towards C corporations. Employees want C corporations, and you get the benefit of the QSBS if you ever, if you become successful and you sell the company for a large amount. Good? Okay, very quickly, I talked about the difficulty with an LLC. Again, you can do them. The document to form the LLC is very short. You have members of the LLC. They are similar to stockholders. You have managers who are similar to directors and officers. The key thing is the operating agreement. LLCs are creatures of contract. And because they are creatures of contract, it means that this operating agreement is very important. It's also very complicated. This is what makes the LLC difficult to manage. Corporations, on the other hand, you file the charter with the Secretary of State. Some contents are optional. This is the standard provision. I mentioned this for the lawyers. In the United States, if you try to sue a director for breach of the duty of care, being careful, getting information, if you try to sue them for money damages, you can get rid of this in the charter. You can say that you can sue me for lots of duties, breaches of duty, but for the duty of care, being careful, getting information before I make a decision, you cannot sue me as a director. This is a very common provision in most charters in the United States, right? It's something directors want. It's something that if you don't have, it's very unusual. Every company I have seen has this provision in the United States. Good? It may sound a little funny, right? Director violates his duty. Why can't I sue him? Right? He's violated his duty. He was not careful when he made his decision. Why can't I sue him? And the reason is because in the United States, there were lawsuits where people went after directors for failing to ask the right questions, good questions. These were very sophisticated directors. The former dean of the University of Chicago Business School was one of the guys sued for breach of the duty of care. And everyone else said, hold on, if the dean of Chicago can't be careful, how can I be careful? And so after these lawsuits, they all resigned from boards of directors. And so the quality of the boards, people were worried, would drop. And so now this provision permits you to say, for money damages, duty of care, you cannot sue me as a director. Other ways you can sue me, just not for the duty of care. Very, very common provision. We'll have bylaws. There are various meetings, but relatively simple to operate this company compared to an LLC. Good? How are we doing on time? Oh, we just finished, didn't we? Okay. What we will do tomorrow, on Monday, is I'm going to talk about founders agreements. We didn't get there today. And we will talk about intellectual property transfer agreements. These are contracts that are key to the formation of a startup, a tech startup. They are very common. The documents that you receive, you have an intellectual property assignment contract in the materials that Olga sent you. You don't have a founders agreement. Are you guys familiar with what a founders agreement is? Shareholders agreement, yeah. Founders agreement, shareholders agreement. They are more generally familiar. People are familiar with them because they've heard about them. They're actually not as common as you would think. And we'll talk about what they cover. But also intellectual property assignment agreements. How many of you have seen the Facebook movie? Yeah, the Facebook movie. Yeah, everybody, right? Okay. Facebook movie is a lot of fighting. Why? They did not have intellectual property assignment agreements. It's because of that problem, that kind of problem, that you see intellectual property assignment agreements. One other question. There is a TV series in the United States called Silicon Valley. Have any of you seen this TV series? Okay, on VK or on Netflix. Okay, so Silicon Valley. If you have not seen it, you should. It is a comedy. It's very funny. It's about 80% accurate, actually. So you should take a look at that as well. Okay, I will see you on Monday. Thank you.